All right, law nerds, it's time to go live and talk about the Josh Duggar conviction. For those of you that are new here or coming in just for the topic, we're going to talk about the chat. We are, first of all, huge thank you to our mods, but it is outside of our normal time, so we are light on mods today. So if Google swoops up your comment into the land of never to be seen again, we are probably not going to get to approving those today. So please just be mindful in the chat of that because this is a live stream and I appreciate you. Josh Duggar was convicted today of the 2 counts that he was facing after about a week of trial. This whole prosecution went fairly fast. Today, I'm going to talk about potential sentencing, the procedure that comes next. I put up a poll. It looks like we're going to look at the jury instructions and see exactly what they considered on these charges. We can look at the witness list, or not the witness list, but the evidence list. I have that as well. And we'll just talk about what this jury did. And this was a pretty quick case. All things considered, that's what it is. So we will move on. If you saw the thumbnail for today's video, that is his new booking photo. Yep, that is his new booking photo. We're gonna pop that up on the screen. I mean, this does not to me look like someone who appreciates the gravity of what's going to happen here, but this is the new booking photo. This is from today. This is from being booked in after trial. Took off the tie in the white shirt. And I don't know. I'll be interested to see what you all think of this booking photo. But what we are going to do in the chat is what we always do in the chat. We are not here to diagnose anyone, wish ill on anyone, wish harm on anyone. He has been convicted. We are going to talk about prison. Just be mindful that we are absolutely always law nerds, even when we're like, well, yeah, prison for you, buddy. Prison for you. Because he is going to go to prison, and that is what's going to happen next. Let's talk about all of this, and I'm going to answer your questions. I'm going to leave a lot of time for Q&A. I know there's questions about sentencing, the federal criminal process, all of that. So we will get to that when I get to Q&A. First, we're going to just do a breakdown. It is time for a breakdown. Let's just get rolling. Thank you all for being here. We should just talk about this stuff.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
I think we're just going to start at the beginning and go over the indictment. We'll do, not in detail, but we'll look at the indictment again that was passed down. Again, an indictment comes after a grand jury has heard evidence. The standard is lower than at a criminal trial. It's not beyond a reasonable doubt, but it's a reasonable probability to hold somebody for what they've been accused of. So we're going to look at the indictment real quick, the 2 charges, and then we will look at the verdicts, and then we will look at the poll and see if the jury instructions would help. It looks like 92% of you are saying, yes, the jury instructions would help. Here's what I really like about the jury instructions is they break down every step of this is what the jury must consider. And it's really at the heart of how they come to a decision-making process. So we're not going to sanitize that. Monetization, no monetization. The information and the facts are more important. So we're not going to sanitize those. So when we get to the jury instructions, the language is going to be the language of the charges. It's not going to be salacious. We're definitely not making this a salacious coverage because that's gross and the charges are gross. But this is also reality. These are the charges. These are the things that happened. And then we're going to talk about potential sentencing, federal sentencing, and things like that. So let us just pull up this indictment. I also have a playlist on the channel. If you want the in-depth of the indictment, the law in motion, the motions in limine, and all of that, there's a whole playlist here. We're not going to really rehash that today because tonight there is a members only live stream. I should have said that before I brought this up. So for those of you that are members on Patreon or here on YouTube, or become members before 7 p.m. Central Time tonight, there is a members only live stream this evening. I always say, you guys, this one might be a little shorter, and they're always 2 hours or more. Always. So that is this evening for all of you that are members. Just remember, we will be meeting again for a second law nerd breakdown, and that is that is a really fun way for us to not just get together and chat, but to have lots of Q&A and talk about all the cases we've been covering. So let us get into this indictment. Again, a pretty simple indictment, 2 counts. Count 1 is receiving of the CSAM images, the CP, and that is between or about May 14th, 2019 and May 16th in the Western District. Joshua James Duggar knowingly received CP images, CSAM images, as that term is defined in 18 USC 2256(8)B, using any means and facility of interstate or foreign commerce. That means generally in this context, the wires. We know this is over the internet, so that is the internet. Count 2, possession of the thing. So receiving the thing and then possessing the thing, which is why this possession is a lesser included crime. And we'll talk about what that means to the receiving, because once you receive it, you also then have it. So this is different than if they can't prove that somebody received it, but just prove that they had it. We'll talk about how those 2 factual scenarios break down if it comes up in Q&A. So between May 14th and May 16th, Joshua James Duggar knowingly possessed material containing images of CP as the terms defined, including images of minors under the age of 12. That had been in interstate commerce as defined in section 2252A, subsection A5B and B2. We'll get into those as we get into the jury instructions. The forfeiture allegation means that the stuff that you use, like the shit that we seized and the shit that you used, we get to keep and then we get to sell. This carries up to 20 years in prison. It can carry up to a $250,000 crime. And it also contains, it also has a 5-year mandatory minimum, which means no matter what the judge does, it cannot be less than 5 years. It cannot be less than 5 years. So Happy and You Know It 28, you asked the relevant question, why are receiving and possessing 2 different crimes? Receiving means they have to prove that you received it. Possessing just means that they proved you possessed it. So if they seized a computer and it had CP on it, but they can't trace back how you got it, that would just be a possession. But in this case, it was a sweep of the internet. So they actually saw the hash files coming into the IP address, then searched the IP address, then found proof that it was possessed on the device. So they had the receipt of it over the internet plus the possession. Sometimes you just have a possession. You can't trace back the digital on the receipt. And they charge both because if a jury said, well, you know, I don't really understand how the police did this or how they tracked it, or if that IP address is his IP address, or if there was something shady with the router. Like, I don't understand. I don't necessarily believe that it came through the internet in that way, but I do believe it was on the computer and he possessed it. So that's why they are charged both, because a jury could convict of one and not the other. In some factual scenarios, you can have possession without receiving. It's very unlikely you would ever have a receiving without possession, because if you can prove the greater crime, you can generally prove the lesser crime. So hopefully that makes sense. And as we get to the jury instructions, you'll see those differences, because we're going to go through exactly what the jury would have been told by the judge and was told by the judge to determine. So let's get to the verdict forms, and then we will go to the verdict forms, and then we will go to the, stop being shady, internet. No, it's not the internet. It's me. It's operator error. We'll get to the verdict forms, and then we'll go into the jury instructions, and then we'll go into questions, because that's what it is. All right. I'm so glad that when they published this, they redacted it for me. I didn't have to redact it. Thank you, federal court. But federal court's very mindful. Verdict form count 1 on the crime of receipt of CP as charged in count 1 of the indictment. We, the jury, find defendant Joshua James Duggar guilty. This date, signed foreperson. In the United States, verdict form count 2 on the crime of possession of CP as charged in count 2 of the indictment. We, the jury, find the defendant Joshua James Duggar guilty. 12/9/21. Foreperson signed. These are the verdict forms that would have been handed to the judge. These are officially filed. So this is exactly what it is. Somebody signed the wrong date, or it looks like they signed 2019 and then went and fixed it to 2021, but they might have been looking at the date of the crime. And then that was initialed and fixed. So there we go for the jury crimes. So This is for the jury verdicts. So these are the verdicts. These are the verdict forms. Very simple verdict forms. Other cases that I've covered have much more complex verdict forms where you have to find if there's lesser included, you have to find if there's circumstances. This is very much, was it this? Was it that? That's it. So let's get into, oh, hello, there's like over 5,000 of you here. Hey, just a note, because we are talking about sensitive topics and a sensitive subject and a very polarizing individual who's been convicted of very awful and disgusting things, we try to keep the chat a conscientious place. I always default to the no name calling. It is set to subscribers mode. So if you cannot chat, it's probably because you are not a subscriber, and that is okay. It is your choice. But if you would like to subscribe, and the chat will become open to you. But that is because we do get trolling on these topics, and I don't think it's fair, especially if people come in and make comments about other members of the family, etc. We are not here to foster hate. We are here to talk about the facts and not the fuckery. So that is why the rules are the rules. And because we are a midday extra stream, our mods are working very hard. But with regard to comments that might get blocked by Google or by Nightbot, which is automatic, if I cannot get to those and we cannot approve those, just know that it's because the streams get busy. And thank you. That is Google making those decisions, and we're letting them go when we are shorthanded. And that is my choice to do so. We will get into the exhibit lists in a minute. George, why are you being so loud? The Pawnards are having a whole moment. The Pawnards are having a whole moment over there. All right, let's get into these final jury instructions. When I left the district attorney's office in LA, I can tell you, I did not think that I would be reading jury instructions again to anyone. It was definitely not on my radar, but I also find them very, very helpful, because then you understand the jury was told to consider this, and that is what they're considering. And I think that it is the best way to break down exactly what these crimes entail for the jury to consider. This is exactly what they would have been told. Like, these are so nicely done. Not all state courts make it this easy. The one thing about federal court that I don't like that there's no photography, there's no videography, there's no audio stream. We don't know what happens except for those that are in the courtroom reporting, and I'm glad that there were. But the verdict forms are so easy to read, like, just thank you. So these are the instructions laid out. It is not the longest jury instructions I've ever seen. They're only 20 pages long. We're not going to go through all of them. We're going to go through the charges. So description of charges and burden of proof, defendant's prior similar acts, count 1, count 2. These are the instructions we're going to go through. We're not going to go through balancing credibility of witnesses and expert testimony and such. It's standard in every trial, but the instructions on the charges matter. So let's go to the instructions on the charges. That looks like should be on page 7. God, they're so easy to read. They're so nicely laid out. Thank you, federal court, for making everything so easy. Credibility, expert testimony, description of charges, and burden of proof. So this is where the jury is told what they are to consider. And for any of you that have been on jury duty, then you completely understand this. For those of you that haven't been on jury duty or aren't in the United States, this is what the jury is told, how to govern their decision-making process and what they have to find. So I'm just going to put on my best judge voice and wait, where's my gavel? I need a gavel. We're going to get a gavel, and we're going to just, I'm already in a black robe because that's what I live in. So we live in black. We've got a gavel. Ladies and gentlemen of the law nerds, the jury instructions are as follow. Final instruction number 7, description of charges and burden of proof. The indictment in this case charges Mr. Duggar with 2 different crimes. Count 1 charges that Mr. Duggar committed the crime of receipt of child pornography in violation of federal law. Count 2 charges that Mr. Duggar committed the crime of possession of child pornography in violation of federal law. Mr. Duggar has pleaded not guilty to these charges. The indictment is simply the document that formally charges Mr. Duggar with the crimes for which he is on trial. The indictment is not evidence. At the beginning of the trial, I instructed you that you must presume Mr. Duggar to be innocent. Thus, he began the trial with a clean slate with no evidence against him. The presumption of innocence alone is sufficient to find Mr. Duggar not guilty and can be overcome only if the government proved during the trial beyond a reasonable doubt each element of the crime charged. Keep in mind that each count charges a separate crime. You must consider each count separately and return a verdict for each count. Please also remember that only Mr. Duggar, not anyone else, is on trial here, and that Mr. Duggar is only on trial for the two charges for the two crimes charged and not for anything else. There is no burden on Mr. Duggar to prove that he is innocent. So this is all explaining the burden of proof. There is no burden on Mr. Duggar to prove that he is innocent. Instead, the burden of proof remains on the government throughout the trial. Accordingly, the fact that Mr. Duggar did not testify must not be considered by you in any way or even discussed in arriving at your verdicts. Final instruction number 8, defendant's prior similar acts. You heard evidence that the defendant may have previously committed another offense of child molestation. The defendant is not charged with this other offense. You may consider this evidence only if you unanimously find it is more likely true than not true. You decide that by considering all of the evidence and deciding what evidence is more believable. This is a lower standard of proof than proof beyond a reasonable doubt. If you find that this offense has not been proved, you must disregard it. If you find that this offense has been proved, you may consider it to help you decide any matter to which it is relevant. The underlying charges. You should give it the weight and value you believe it is entitled to receive. You may consider the evidence of such other acts of child molestation for its tendency, if any, to show the defendant's propensity to engage in child molestation, as well as its tendency, if any, to determine whether the defendant committed the acts charged in the indictment and to determine the defendant's intent. So to see that, whether or not that helps them, if they decide that that is more likely true, they're allowed to consider it to determine whether the crimes charged are more likely true. Remember, the defendant is only on trial for the crimes charged. You may not convict a person simply because you believe he may have committed similar acts in the past. Elements of count 1. The crime of receipt of child pornography is charged in count 1 of the indictment has 3 elements, which are the jury has to find each of these things beyond a reasonable doubt. First, that between on or about May 14th and on or about May 16th, Mr. Duggar knowingly received visual depictions of child pornography. Second, Mr. Duggar knew that the visual depictions were of a minor engaging in sexually explicit conduct. And third, that the visual depictions had been mailed, shipped, or transported by any means, including by computer, in interstate or foreign commerce. If all of these elements have been proved beyond a reasonable doubt as to Mr. Duggar, then you must find Mr. Duggar guilty of the crime charged under count 1. Otherwise, you must find Mr. Duggar not guilty of count 1. That's why the computer matters, because they have to prove how it transported. And this is why the jury has to see the images. The jury has to see the images to know if they can convict him of knowing that the visual depictions were of a minor. In this case, we know that they are dealing with substantially young minors. So it's not going to be a question of, is this person on like 3 days away from turning 18? That's not what we're talking about here. So that is why they need to see it. And that is why it comes up, because the government has to prove that Duggar knew that these were depictions of a minor. And when it comes to that knowing, the jury can use those prior acts to say, no, he knew, because we've seen that there is a proclivity for this. There's a propensity for this with substantially young minors, prepubescent minors, but also because we have seen these images and we know, and the jury sees those unredacted, unchanged as they would have been found on the computer. So again, don't go looking for that because you can't unsee that. I always warn, just know that it's horrific. And if you think it's horrific, it's worse than probably what you can imagine in your head. So just don't try. Know it's awful. Know that the lead investigator described what was found on this computer as the top 5 most disturbing images that they have ever seen in their career doing this. So that's all we need to know about it. It is horrific stuff. And And that is going to be an easy element for the jury to find once they see the images that were recovered here. Final instruction number 10, elements of count 2. The crime of possession of child pornography is charged in count 2, has 4 elements, which are, and this is, the crimes are different, right? So this has 4 elements, this has 3 elements. Not all these elements will overlap. First, on or between the dates charged here, Mr. Duggar knowingly possessed computer files on an HP all-in-one desktop. That's why we saw that motion in limine, proving what the desktop was and saying, hey, can we just go with the trade inscription and the trademark inscription? We don't have to bring in an expert to say that's an HP computer. Knowingly possessed computer files on an HP all-in-one desktop computer that contain multiple visual depictions of child pornography. Second, that Mr. Duggar knew that the visual depictions of the minor were of a minor engaging in sexually explicit conduct. And third, that Mr. Duggar knew that such items contained child pornography, which involved a prepubescent minor or a minor who had not attained the age of 12 years of age. Fourth, that the HP computer or the computer files containing the visual depictions had been shipped or transported using any means or facility of interstate or foreign commerce or affected interstate or foreign commerce by any means, including by computer. You have heard evidence of more than one visual depiction involving the offense. You must agree unanimously that at least one specific visual depiction possessed by Mr. Duggar involved a minor under the age of 12 years old, and that this specific visual depiction was possessed using or affecting interstate commerce means. So the jury has to agree which image. And this is why we're going to go through the evidence list, because the jury has to say, evidence item number 12, 13, and I'm making up these numbers. We'll go to the evidence list, but we agree that these images are images that depict this. There are, the jury would be able to do that based on the images at hand here, because the children are clearly not over the age of 10. They are clearly not over the age of 6. They are clearly very young children. So this can have a higher sentence because this is the subsection of the crime charged with the children being under 12 years of age. So this is the jury instruction for that specific possession subsection. If all of these elements have been proved beyond a reasonable doubt as to Duggar, you must find Duggar guilty of the crime charged in count 2, which actually the sentencing might be, I need to go back and double check. The sentencing might be the higher one on count 2, the possession, and not count 1, the receipt, because the receipt only has the 3 elements, the possession has the 2, but either way, they are lesser included of one, lesser of the other. And it actually might be that count 2 is the greater and count 1 is the lesser. I'll go back and double check. Either way, the sentence, and I'll just pull it up, but the sentence maxes at 20 years with that 5-year minimum sentence. Final instructions number 11A, definition. This is what they are given to determine what the images are. So it is defined for the jury. So there is no question about what these things are. The depictions can be, the definitions can be a little explicit. So we are going to go through them. This is what the jury had to find. These are the definitions of what the things are. If you do not want to know, less than 5 minutes, come on back. But I'm just going to let you know that we are going through the definitions section of the jury instructions, because this is what the jury had to determine. And this is what the words mean. Defining what everything means is very important. Visual depiction, as used in these instructions, the term visual depiction includes any photograph, film, video, picture, computer, or computer-generated image. Computer-generated image is important when it comes to this category of crimes because it doesn't matter criminally if the image is produced with a live minor or if it is a computer-generated image of a minor. So it does not matter whether they prove, and they do not have to prove, that the child in the image is a actual child that lived and was abused and had these images taken. It can be a computer generated image. And that is something that very much happens as people were trying to get around some of these laws and be like, well, it's a computer generated image. It doesn't matter under the law. So that is why this is in here. It can be a computer generated image or picture, whether made or produced by electronic, mechanic, or other means. So you don't have to prove that this child is this name, this age. You don't have to prove any of that. You just have to show the image and then prove the rest of the things to the image. Hopefully that makes sense. Child pornography. The phrase child pornography means any visual depiction of a minor engaging in sexually explicit conduct, whether the minor was engaged in the sexually explicit conduct during the production of the depiction. So where the minor was engaging in the explicit conduct during the production of the depiction. And when I talk about this in other cases, because I've been asked about other cases where you have people sending photographs. People asked about this with regard to James Charles. This is when you get to what the sexually explicit conduct is. We're going to get to that definition in just a second. But just sometimes images of bodies doesn't necessarily count. We talked about this with the person who sold a picture of themselves on OnlyFans as a child without underwear on, but there has to be, for these laws, there has to be that explicit conduct. It is not just an image of a naked child. So if you have ever, though those photos are taken off of Facebook and other social media apps and traded in these same circles, to be prosecuted, you have to prove that there is the sexually explicit conduct. And that's where sometimes people find frustration with the laws. And you can find people trying to skirt the laws by asking for things that might not be explicit. And we're going to define that now. So just a whole big warning. This shit's fucked up. We're going to go through what the jury had to define. Minor. The term minor means any person under the age of 18 years old. Sexually explicit conduct. The term sexually explicit conduct means actual or simulated intercourse, including genital to genital, oral to genital, anal to genital, or oral to anal, whether between persons of the same or opposite sex, masturbation, sadistic or masochistic abuse, or lascivious exhibition of genitals or pubic area of any person. When we talked about the Cuties movie, this is where that debate lingered on the lascivious exhibition of genitals, which is where you get this stuff. Lascivious defined because, again, when you are coming to a criminal prosecution, you have to define what all of these things mean for the jury to decide. This is what the jury had to decide. All right. Lascivious. Whether a visual depiction of the anus, genitals, or pubic area of any person constitutes a lascivious exhibition requires a consideration of the overall content of the material. The jury had to discuss this. They had to determine this with regard to the images that are in evidence. You may consider such factors as whether the focal point of the picture is on the minor's anus, genitals, or pubic region, whether the setting of the picture is sexually suggestive, that is the place or the pose generally associated with sexual activity, whether the minor is depicted in an unnatural pose or inappropriate attire considering the age of the minor, whether the minor is fully or partially clothed or nude, whether the picture suggests sexual coyness or a willingness to engage in sexual activity, whether the picture is intended or designed to elicit a sexual response in the viewer, whether the picture portrays the minor as a sexual object, the captions on the pictures. And this is where, when we talked about that case on OnlyFans, the captions can play into it, which is why when I went through this, I was like, look, the captions matter. If you're selling a photo of yourself as a child on Instagram or on OnlyFans without underwear, being like, I forgot my panties, the caption matters, even if the image doesn't matter. So look, sometimes being a lawyer is the worst, and cases like this are the fucking worst. All right, computer. They define computer. They define everything. They define computer. They define interstate and foreign commerce. Interstate commerce means between any combined states, territories, possessions of the United States. Computer means, how do you legally define a computer? An electronic, magnetic, optical, electromechanical, or other high-speed data processing device performing logical, arithmetic, or storage functions that includes any data storage facility or communications facility directly related to operating in conjunction with such a device. By the way, this would, under this legal definition, be a computer. But such term does not include any automated typewriter or typesetter, a portable handheld calculator, or similar device. So phone, yes. TI-87, no. And that is the end of the definitions. It is for you to determine, however, if the HP computer had been shipped or transported using interstate or foreign commerce, which is why they wanted to prove that it was from China, or if the computer files containing the visual depictions had been transmitted or received over the internet. And that is where that broad definition matters. Additional terminology, proof or intent of knowledge. Intent or knowledge may be proved like anything else. And this is they have to decide. The jury had to decide if he knew that the minors depicted were underage. So the jury had to know that. And so this defines how you prove that someone else knew something. Obviously, he didn't testify. You can't comment on testimony and lack of testimony. So the jury has to infer intent. Intent or knowledge may be proved like anything else. You may consider statements made and acts done by the defendant. So when the jury was asking for the interview by the defendant, they have to consider this as they're going through the jury instructions, which is why what's in these instructions matters so much. Any statements made by the defendant, the statement when the police showed up and they're like, oh, somebody downloading CP, that statement matters to the jury. It's like, does that statement alone prove knowledge or intent? For me, yes. And for this jury, possibly. You may, but are not required to infer that a person intends the natural and probable consequences of acts knowingly done or knowingly admitted. Possession, the law recognizes several kinds of possession. A person may have actual possession or constructive possession. A person may have sole or joint possession. Two people can possess a thing at once. A person who knowingly has direct physical control over a thing at a given time is then in actual possession of it, the computer and the things on the computer. A person who, although not in actual possession, has both the power and the intent at a given time to exercise domain or control over a thing, passwords and such, either directly or through another person or persons, is then in the constructive possession of it. If one person alone has actual or constructive possession of a thing, possession is sole. If two or more persons share actual or constructive possession of a thing, possession is joint. And so whenever the word possession has been used in these instructions, it includes actual as well as constructive possession, sole as well as joint possession. Then it gets into the reasonable doubt standard, which obviously the jury didn't find because they convicted him. And then they go into the process of picking a foreperson. So we are going to jump from the jury instructions into the exhibit list. The exhibit list is not graphic. The exhibit list shows highlights. I believe the highlights are the things that the jury asked for, or the things that are received digitally, but I could be wrong on that because wrong happens. So the exhibit list from the let me just double check. There are names on some of these files. I will just again warn, don't Google. So we will go through the government's list of evidence, and then we'll go through the defense evidence admitted. This is not graphic. There are some names, but they are not graphic. So it's just the list of evidence. So yes, for all of you that are back and are like, is this okay? Yes, we're just, where's Fred? Fred, we need our emotional support cat. Where is my paw nerd? Fred! All right. Let us go through the evidence list and the date offered, whether there was an objection, a stipulation, and whether it was received. And this is the exhibit list. Torrential downpour log for video movie _026.mp4. So this is the Torrential downpour is the system that the government used to literally sweep the internet with like a net to find. It's a program that runs to find these hash files. So these are the initial things, and these will go in order. These will go in order. Torrential downpour log for the video marissa.zip. Thumb drive containing video movie. This is that torrential downpour log for that movie, and 65 images from the Marissa zip file. And then in quotes it says CSAM. So those are the materials that that they are discussing. This log is the log of the log of the government seeing it and then getting the search warrant and then tying it back to the computer at the location. Search warrant document map of Wildcat Creek Road, view 1 and 2, search warrant photos, and these are all different search warrant photos of the location. These are going to be photos of the computer, the desk, and all that stuff. Search warrant, the final search warrant photo, Apple iPhone. This would be the iPhone taken at the time that we heard a lot about in the pretrial motions and the motions in limine, that Josh was like, I should call my attorney. And then the government was like, yoink, what you're not going to do is use that phone. We have a search warrant for it. Thanks. We're going to take that. Statement of rights form, Josh Duggar, November 8th, interview with Josh Duggar, wholesale motor cars pay records. That's going to be to show again that during that time, no one else had dominion and control over the computer or access into the office, even though they say somebody else, some other dude did it. Stipulation regarding Exhibit 23 being the pay records. We saw motions in limine on those records that that they didn't want the government presenting the records in a way and be like, and Josh Duggar told us this. It was just the custodian of records gave us these. They're true and accurate. So that's why there's a stipulation regarding the payroll records. The HP laptop, the MacBook computer, virtual machine print screens of the HP desktop Windows partition, virtual machine print screens of the HP desktop Linux partition, thumbnail images from the cache, and they are marked obscene when they are the images. The EXIF information from thumbnail images from normal folder, thumbnail images from a cache folder, EXIF information from the thumbnail images from large folder, images from unallocated space that match thumbnail images from normal folder, additional images from unallocated space, Tor browser bookmarks, recently used file data, Tor files on the HP desktop Linux partition, torrent file hash values, torrent file contents, all the computer stuff. And then other movies, storyboards of the movies, a pedomom.wave file, storyboard of that file, mamalinda.mp4, and these other ones. Some of these are more graphic than I thought. So we're gonna just what we're just gonna do is just look. There are some things that the world doesn't need to know, but these are the files that the jury would have seen. Yeah, so we're not sensationalizing horrific images of abuse. It's just we're just not. Recently used file data. So these are all the things showing like your browser history, though you might delete it, is not gone. Virtual machine print screens, Apple Notes from MacBook, emails relating to Intel 1988, torrent files on MacBook, Covenant Eyes email, another Covenant Eyes email. Fred, come here, buddy. Don't be coy with me. You know you want to come say hi to the law nerds. Fred's like, yes, I do. Yes, I do. Say hello. Say hello. Hi. We're not purring. No, not yet. All right. That's fine. Oh, no, not on the iPad, Fred. Sorry. He's like, Bottom, you put me on it. No, I didn't. Maybe a little. All right, where were we? Covenant Eyes emails. So we talked a lot about Covenant Eyes in the pretrial motions. Images from defendant's iPhone 8. Those images are going to show the defendant in the car lot at the time. So they used a lot of images to show, look, at the time someone was on the computer doing this, there are pictures from the phone that are geotagged to the same location. So if you want to know if somebody's in the same place and location, the geotagging on the phone pictures is one of the things they really leaned into for this. iMessages, images, iMessages, all for the same, to show that he was at the location. And iMessages in the detention hearing indicated like, oh, I'm still at the car lot, home soon, that kind of stuff. The media history, and then the timeline created by the lead investigator here. So those are the 85 exhibits. some of the obscene ones are all the ones in blue, because those A are going to be sealed, B, those are going to be handled differently in just the way the court handles exhibits, because that needs to be done in a mindful way. This is the defense exhibit list of everything that was offered in. The exhibit list for the defendants is an 8 GB SanDisk thumb drive, and these are blue. Again, I think I suspected correctly that these are the things that contain the CSAM images. These would have been presented by defense because they would have been the things used by the defense expert to go through and do the expert analysis of these items. The 8 GB drive, the 16 GB drive, the 2 GB drive, the 8 GB drive, and the 4 GB drive. So these are all the things that their expert would have used. The different torrential downpour log files from different days, different photos that are Bates stamped, which keeps them in order. So photos from item number 19 to item number 38. Just kidding, through item number 40. The search warrant return is after the government gets a search warrant, goes out and serves the search warrant. They then go back and file a search warrant return with the judge saying, we searched this place, we found this shit, search warrant return. So it shows, I don't know what the defense used this for. I didn't look into that part of the testimony. I don't even know if it was reported what they used the search warrant return for. Search warrant inventories, email correspondence and shipping labels, photo identification of the file name, HP computer link files, screenshot from the HP, screenshot from the MacBook, screenshot from the Apple iPhone, Josh Duggar interview, pages 13, lines 1 through 13, Josh Duggar interview, page 15, Adam Walsh examination worksheet, GNOME control center desktop, Linux partition size, underscore not available. I don't know what that is. Clearly somebody objected to it. Application state for GNOME exhibits and Snap Store uTorrent. So that all is stuff that they would have used. It sounds like with their expert. There's a few things that were objected to here, but most of it wasn't. And it didn't matter because the jury said, what we're not going to do is find Josh Duggar not guilty. So they found beyond a reasonable doubt that the images were what they were, that Josh knew what they were, and that he did the things. Again, this carries a 5-year mandatory minimum sentence. So when sentencing comes up, he will be sentenced to prison. The question is how long and if he will be fined in addition to it. Often, individuals are not fined in addition to a criminal sentence like this when you go to prison. It doesn't mean it can't happen. It may happen. It well could happen. And I'm just going to make sure. I see our chat flying. I know there's quite a lot of you in here. I'm going to make sure that it is I think that's as slow as we can. I think that's as slow as we can get. So apologies. Slow mode is on. And with that, there will be time for sentencing memos. He's going to be in custody until sentencing. Again, he is going to do a minimum of 5 years. And with the minimum of 5 years, him being in custody pending sentencing means he will stay local. And his family can come visit. Once he is sentenced, he can be sent to any federal prison. Whether they will keep him local so it's easy for his kids to visit or send him to like upstate New York or something so it's harder will be partly in discretion of the judge, partly with space and the prison system. And if there's concerns about keeping him safe based on his minor celebrity and based on the nature of the charges, they might have to place him somewhere where he can be kept safe as well, because that is their duty and obligation. So with that, this will be put over for sentencing. What will happen for sentencing is that the defense and the prosecution will file sentencing memos. The defense will point out all the reasons why they think Josh should get a downward departure or a lower sentence. Hey, he's not been convicted of stuff before. Hey, he has 7 children. Hey, he has a job, that kind of stuff. And the prosecution will be, hey, did you hear the testimony? Did you see the images? Did you hear Bobby Holt? Did you hear what he's been accused of before? Consider all of that. Put him in prison. He's a danger to his own children. He's the worst. And so the judge will take those 2 sentencing memos under consideration. Sometimes can hold a sentencing hearing, sometimes not. There will not be a there will not be generally victim impact statements, but there can be impact statements from family on his behalf or against him. So there can be a full sentencing hearing where people choose to come and testify. It will be very interesting to see if people choose to testify at his sentencing and then what the judge decides to do. Keep in mind that with a federal sentencing, the judge may not proclaim a sentence on that day of the sentencing hearing. The judge will hold the sentencing hearing, consider the sentencing memos, hear from any witnesses that may be called for either side, and then can take it under consideration and write a formal sentencing opinion. And that is something that we may see from this judge, that it's taken under consideration. And generally, it will matter when they are going into the higher realms of sentencing or into the very low realms of sentencing, that there will be a full written sentencing opinion. And I won't be surprised to see that. So, minimum of 5 years. If the judge considers the prior acts, look, the jury wasn't finding the prior acts, but the judge has heard this testimony. The government will probably bring it up in their sentencing memo. I'd be shocked if they don't. If the judge considers the prior acts in danger to the community, the judge could get into half, 10, which is 5 more years than the mandatory minimum. So it's like double the mandatory minimum, but it's half of the max, which would be, for federal sentencing, reasonable. Federal sentencing tends to be low, especially when they are considered non-violent crimes. And I know, chat, I feel you. I hear you. I know what you're going to say, but these are image-related crimes. They are considered non-violent crimes because this is not the production of the things, it is the having of the things. So these are considered non-violent crimes. But if the judge considers the prior bad acts, the judge can take that under consideration, can't add to the sentencing because of that. He doesn't have priors that he's been convicted of. But the totality of the circumstances might allow the judge to bump the sentence up into 15 years. Frankly, I would be shocked if he got 15 years. I think 8 to 12 is probably where we will see this, though it depends. The judge could find more. It depends on what happens at that sentencing hearing, which is why I will keep my eye on the sentencing hearing. I do not think that the judge is going to give him the maximum. It's very rare in federal cases that someone with no record would get maxed out. It can happen. It's just exceedingly rare. So I would not put my hopes on the fact that he's getting 10 years, 20 years. I would put my sights after trial in that kind of 10 to 15 realm. And that's where I would be like, okay, this judge considered everything. 10 to 15. I'm going to get to questions, and I saw a few things in the chat because distracted. I saw a few things in the chat about the appeal. It's the job of the defense attorneys. They are going to appeal. They're going to appeal the ruling that the judge allowed the testimony of Bobby Holt in. They're going to appeal a few other things. Of course they are. It's their job. Almost every criminal conviction gets appealed particularly if the individual has the money to have prior counsel to appeal it. So when we talk about money and wealth playing into our justice system, money and wealth does matter in that you can now pay the attorneys to go through all of the transcripts, to spend the time to do an appeal, where if you didn't have that money, you might not be able, unless there is a glaring appealable issue. In this trial, there is no glaring appealable issue for me. It doesn't mean they're not going to appeal and have it get denied. Their client's going to say appeal everything you can appeal, and they're going to. I don't think it'll get overturned on appeal. At sentencing, you will probably see the judge sentence on both counts, but you're not going to see them sentence them consecutively. It doesn't mean you get the maximum on count 1 and then you get the maximum on count 2, and you have to do count 1 first and count 2 second, so you stack up time. That's not going to happen. These charges overlap. It's one thing of activity. So one act of stuff. So they're not going to get sentencing on the 2 so that it adds more time. It will be sentenced concurrently. And the reason that the judge would do that is because on appeal, the court finds that count 1 is unconstitutional. For a broad example, the court goes, oh, count one sucks. It's unconstitutional. well, then you don't have to resentence someone on count 2. It just defaults. Count 1 gets bounced and it defaults to the sentencing on count 2. So you'll see him sentenced on both most likely, but you won't see time for count 1 then time on count 2. So somebody's saying, I thought the mandatory minimum was 20 years. I don't know why you would think that. No, the maximum is 20. The mandatory minimum on these counts is 5. I've never seen a mandatory minimal sentence in any crime, including first degree premeditated murder with special circumstances, be 25 to life is the highest minimum sentence I've ever seen. And that is in first degree premeditated murders with special circumstances, where 25 to life and a few other crimes. But for nonviolent offenses, mandatory minimums are not that high and would never be in the 20-year range and aren't on this. So whoever reported that is inaccurate and does not understand the way that this all works. So Rosalie, I'm not saying that it's you. I'm just saying wherever that is not accurate. Mandatory minimum of 5 years in this case, maximum potential exposure of 20. So I'm going to try to get to some questions. I should swoop. I feel like I've talked a lot. I'm sure you'll have lots of questions about process and what happens next. I appreciate you all for wanting to know the facts and the facts of how cases like this work. And I'm sure there are a lot of you that are like, why is the sentencing so low? Right? Why is the federal sentencing so low? Why is it only 5 years minimum? I understand you. I hear you. These are the laws of the land. This is considered a nonviolent crime. The sentences for creating stuff like this are higher. The sentences for hand-on abuse are higher, but not for these. From Scott Nesdell, who is a supporter of the channel, what happens with his own children as he is their father after he is sentenced to prison, after he is released from prison? It depends of what the terms of release are. And it depends on what the terms of release will be. And it determines what their mother chooses to do. So he is their father. This will not terminate parental rights. So we will see what happens. There will likely be some period of post-release parole, but there might not be if he serves most of his time. So it's just going to depend on if he gets good time, work time, and things like that. So it depends on how this goes down and how he is released after he serves his sentence and what his sentence is. And then again, if at the time he leaves prison, he is divorced and the kids are primary custody with their mother, things can change there. So let me get to the super chats that I missed and let me get to questions, because I will. You know what? I need to check. I'm not going to assume that he will have to register. I need to double check on this particular crime, because not all CP crimes make you register, but I will need to check. My assumption would be yes, but I need to double check that before I say yes. So I will share that on social, but I want to look at what the federal statute actually says. Corrine says, how does a charge like this not terminate parental rights? Because government overreaching is something that is not looked at lightly, even though when you look at this, you're like, but also what the fuck? That would be something that would have to happen in the family law courts. And given the limited knowledge I have about this family, I don't know if that's something that his spouse will ask for. So again, our system allows someone to serve their time and be considered rehabilitated. And all of you can, some of you are going to be like, but on a crime like this, is that possible? Our system is built on, you did the thing, you're convicted of the thing, you go to prison, and then what happens after. So let us get to some of these super chats. Thank you guys for the super chats. I appreciate it. The video is already shockingly yellow, but I decided that it was more important to talk about the facts than to try to make up words and read the jury instructions. And YouTube will determine if it is educational and factual, or if they are going to bing it. It's fine. I'm going to put the link to the child abuse hotline down below. and some of the proceeds from this are going to be donated to that anyway. So if it ends up being monetized, I haven't monetized most of my Duggar videos. But if it ends up getting monetized by YouTube, then we'll just send the money there, because there is only one child abuse hotline in the United States, and it is donation based. So we'll share that down below. Natalie, that's $100 super chat. Thank you so much. Thank you for all your work on this case. As a child parishioner of an independent fundamental church, this type of abuse is allegedly far too common in this denomination. Your facts, not fuckery approach is refreshing. At the very least, more like soul healing. Natalie, that is a very kind super chat. Thank you. Again, I am here to bring the facts so y'all can decide how you feel about it. And ultimately, so all of you can determine if these laws work for you. Like, you can look at the laws and be like, are these laws enough? Are these laws sufficient? And what could change? Is a 5-year mandatory minimum fine? Is a 5-year mandatory minimum too low? Some might say, is a 5-year mandatory minimum for just having images too high? So I try to bring the facts so you can decide how you feel about it, and engage in that process in our country, because the foundations of our legal system are that we're able to participate with our legislatures. That is their role. We elect them to make these laws or change these laws, and that is their fundamental goal in service to the people. But if our laws are bad, our jury system can never get it right, because you can only convict someone on the laws that are on the books. You don't get to just go rogue. So that is very important to understand the why and the how of how our system works. Julia Blair said, got my kitchen clean this morning, listening to a replay, excited to hear alive. I know, lots of Emily this week. Little Kitty Cat said, there's a K-pop song with opinionated, but I'm always spitting straight facts as a lyric, and I think of you every time I hear it. Little Kitty Cat, thank you so much for that super chat. Kelly Egan said, the fact that he's smiling is sickening. The booking photo is a whole fucking thing. Katie said, thank you for your breakdowns, Emily. Happy justice prevailed in this one. Me too. Psychedelic Yoda, I finally got the punctuation right this time. Thank you for the super chat saying thank you for the breakdown. I appreciate it. Amanda sent a thumbs up super sticker. Appreciate it. Nicole said thank you for the facts and for the whiskey fund. We're definitely going to be drinking whiskey on our members only live stream tonight. Marissa said, thank you for your coverage. As a forensic nurse, I am grateful justice was served in this case. I'm hoping he gets the maximum and his kids get the care they deserve. I also am hoping that his kids get the care, and not just his kids, but also his sisters. I mean, I'm very mindful of the fact that when his father took the stand and said, I don't remember what happened, that some of those Jane Does are related to him based on reports, and how unsupported and not valued that would make someone feel when your father can't and won't stick up for you and protects the person who harmed you. That level of betrayal of trust and damage is just heartbreaking. So, as I look at this case, there are some things that are silver linings. One of them is that at least how this happens is brought into the light. 2 is that it doesn't matter who you are or what money you have, the feds can come for you and justice can be served. And 3rd, that that people who were part of his church, people who were family, friends, and close to Jim Bob Duggar stood up and testified for what was right, and stood up and testified for the facts. And though I had a lot of questions, and when we went through the motions in limine with Bobby Holt, I had a lot of questions. I'm like, but you brought this person into your home. But at the end of the day, it would have taken a great deal of courage to stand or sit in a courtroom in front of a family that you were family friends with, and know that your testimony could send someone to prison, and look their father in the face and still testify. That takes a tremendous amount of courage. And that is something that, while I disagree with earlier things, that is something I don't think that can be downplayed, and maybe is a silver lining in breaking that kind of code of silence that seems to have surrounded this family. And that matters. And that matters a lot. So let's continue on with these super chats. Um, oh, JD Lady 173 Mary. I'm sure I didn't put the spaces in the right places, but thank you. Since he was offered a 10-year plea deal, don't you think he'll get at least that? Not always. And the government was going to recommend 10. The court can choose. If the government comes in and say we recommend 10 years, the court can still give him 8 or 6 or 4. The court gets to decide. So it's a great question, but that's not how that works in federal court, which would be so frustrating to me. Like when I prosecuted, it was like the people are offering this amount of years, 15 years, 2 years, 1 year, 3 years probation, whatever it was. And the court was like, okay, 3 years probation. Or the court said, no, we're not doing that. But to be like, Your Honor, we recommend this and have the court go, we'll take the plea, but also fuck you, we're going to do less would be tremendously frustrating to me. It's no, I like control. Don't undercut my plea deal. Wakanda Forever said, how do you prevent a juror in deliberation from improperly outweighing prior acts, like in a police-involved shootings and or injury, for example? The other jurors are empowered with the jury instructions, and the jurors have to have that conversation and self-regulate. It is up for the jurors to determine that in the room themselves. Victoria said, plea deal 10 years. Does that mean he will get more? Not necessarily. Anna refused to cooperate. Now children will be interviewed. Maybe. Can she be charged if outcries made? I don't know if there was obstruction. That would be the only thing I would think that would be charged. If there was obstruction, maybe. I don't, it's hard to speculate on because we don't know. We do know that the children from earlier on, I don't know if it's been done now, that the children were not interviewed. The government mentioned that because the court asked them about it. But we will see what is determined and we will see what happens. I don't know if that will happen. I think it is unlikely that the feds will go after her. So, donation to the facts. Cheers. Thank you, Ashley. We are all about the facts, even when the cases are fuckery, because it's just. Courage to go against her husband and church. I mean, it would have taken a tremendous amount of courage. And I think in these criminal cases that are particularly so dark, there's always something that's a silver lining. And this is a silver lining of a woman who stood up and I think did the right thing. And that would have been, again, tremendously difficult. But I also hope it encourages other victims to know that they are believed, they are supported, and the courts are not here for this fuckery, even if they feel like that's their only option. That they have options, and that there are people who will believe them. CM Nelson said, sadly, under IBLP, IBLP, the girls wouldn't expect anything else. Bobby was amazing. She shouldn't have done that. I mean, I guess under their church, that is not what one would expect, which is, I think, why it is so tremendously courageous. And that says a lot. CM Nelson also said, Anna has no choice. She's raised gaslighted Institute of Basic Life Principles, and both families stand by Institute of Basic Life Principles. Diana said, you are the best, Emily. Well, thank you, Diana. Jana Vanderplug, I hope I said that right, said, thank you for explaining it all. As a Dutchie, there's a lot I don't get about the system in the U.S. Jana, there is a lot that people in the U.S. don't get. So never, ever say, I'm international, I don't understand. Look, our system is deeply complex, and I think there are a lot that don't understand our system, even when we're in it. So I absolutely appreciate that. Sorry, I need to check. Just one. All right. There's a lot going on today, y'all. I can't believe it's almost 4 o'clock. So lots of things happening. All right. I'm going to try to catch up on these. Scott said, I love your videos. First live, I watch mostly your videos on the replay. I forgot to say replay crew, we love you. Replay crew, we love you. Victoria Jackson said, plea deal 10 years. Does that mean he will get more? Oh, we did that. Wait, Anna refused to cooperate. We did that. And then Dakota, we are caught up. Question, way back at the bond hearing, there was a request for a forensic interview of his children. Someone on KJ's channel said Anna and Josh denied. Is that even possible? It is. Well, Josh wouldn't have had the ability to, but Anna absolutely could have said, no, I'm not making my children available for a forensic interview. Whether anything will come of that or whether there will be additional investigation into that is unknown. It's possible, but it is unknown. Wonder if Jim Bob is still running for Arkansas legislature. Can you imagine the ads? I mean, I can't imagine the hubris of an individual to decide that now's the time they were running, or maybe it was to distract against this, but there's no distracting about this. And I don't think there should be. I think this should be, I think people should know this is a conviction. People should know. There shouldn't be oh, but he's also running for Senate. No, this happened. This is a conviction. This happened. The evidence was very strong. The testimony was damning and the images were horrific. This should be known. Will there be a Friday Night Live? Yes, there will be a Friday Night Live. We will be moving on to other topics, which is why I wanted to do this in a silo topic so we all can take a bath this evening and just wash off the yuck and then talk about other things. Brittany was in court yesterday. I think we might see a verdict in the Jussie Smollett case. Travis Scott is giving interviews. There is so much to move on to, and I will be happy to move on. So yes. I just wonder if you knew if the children who were the victims had ever been saved. I do not know. These are older image sets, and I have not looked into it that deeply because it is very, very deeply disturbing. So no, I did not do a deep dive into this image set because it is, again, deeply deep. I should ask some of my my law enforcement contacts. They might just know, and then I don't have to deep dive into it. This reminds me of the Wills clan. They had a show about the big family of kids and were a band whose dad essayed the girl. Which is it's just heartbreaking, isn't it? Welcome. Somebody said they all need to be deprogrammed. I mean, it's a lot. Doesn't this charge carry a minimum of 20 years with the possibility of more with children under 3 on his computer? No, this does not carry a minimum of 20 years. This carries a maximum of 20 years, a statutory minimum of 5 years. Should we just pull up the statute? Maybe that would clear, maybe just going to the actual law would help. So let me pull up the statute real quick and we'll go through the mandatory minimum. I did that in my very first video about this, but we can always just do it again. Hold on. Let me go to the link and we will pull it up. But no, I don't know where that information is coming from. I should be. No, mandatory minimum 5 years per the law and the statute. Let me just pull up the statute, which I think I have linked in my notes. Otherwise, we'll just pull it up. Just give me a second to pull that up, and we will just bring the facts of the mandatory minimum. So no, 20 years is not a mandatory minimum. 25 to life can be a mandatory sentence in like first degree homicide cases, depending on the jurisdiction and depending on if there's special circumstances or not. But 25 to life cases, the minimum is 25 years, and then you can get up to life imprisonment. But most nonviolent offenses do not have mandatory minimums that high. 5 years is definitely average. It's kind of the statutory average on cases like this. So let me just see where it is in my notes, which is going to take me a minute because I haven't pulled back into the beginning of the law. Let's see. This is 2252. Hey, let's just pull up. We're just going to help everyone else do their research by pulling it up all together. Let's go to the law, Bob. All right. This is the code section 18 USC 2251. Hold on. As you will remember, let's get into specific subdivisions and do just the legal. Let's just pull up the legal things. Where's our indictment? Here's our indictment. We are looking at, we can just go back and forth. Law things. Here's our indictment. So we're looking at 2252A, big A, subsection A2 and B1. So 2251 through 2252. Let's get down to 2252. Where is our, this is our breakdown. This is not our full 2252. Specifically 2251, specifically 2250. Where's our hyperlink? 2252A1 specifically prohibits, but where is our sentencing? This is 2251, 2252. Under 18 USC 2252, fines and a statutory minimum of 5 years up to 20 years maximum in prison. So the mandatory minimum's 5, up to 20 years minimum in prison. The more severe crime, the 2251 crime, is a statutory minimum of 15 years up to 30 years. But the minimum does not modify 30. The minimum modifies the first number. So statutory minimum of 5, up to 20 years in prison. Convicted offenders may face harsher penalties if the offender has prior convictions, or if the CP offense occurred in aggravated situations. The images were violent, sadistic, masochistic. The minor was sexually abused. The offender has prior convictions for exploitation. In these circumstances, a convicted offender may face up to life imprisonment. That's not the case here. That was not charged here, but you can absolutely get up above that. But it is 5 years mandatory. Let me see if we can just pull up the direct code language of the 2252 AA2, because this is the breakdown. It normally hyperlinks to the specific language in the US code. So let us pull up our US code. There's GPO. Let's see. We want the government site where it's just the code. All right. Here is the code. All of the code. Ugh. No, it is not all of the code. It is just a... Where's the document of the code? Damn it. This one does not have it either. See, this... I should have just... Emily, just pull up Westlaw. No, it's too much work. We're using the free resources on the internet. Let's see. I think this is the most... Does Cornell have the accurate one? It's not always accurate, but I actually know what this code says, so I don't want to. Let's see. When was this last updated? All right. Recent enough that we are relatively confident. 2252A, remember again, he is charged with subsection sub A2 and B1 from 2252A, A1. 2, knowingly receives or distributes the materials, any material that contains the materials. And then you get down to the sentencing, which is B. Whoever violates or attempts to violate shall be fined under this title and imprisoned not less than 5 years and not more than 20 years. So not less than 5 is the mandatory minimum, not more than 20 is the maximum. But if such a person has a prior conviction under this section, and again, that is a prior conviction, not a prior considered by the jury, but not a conviction because the person was a juvenile. Hopefully that clears it up. I feel like we've thoroughly explored what mandatory minimum means. I understand that federal sentencing can be confusing. If you have not been an attorney, it's like, well, what modifies what? But that is not less than 5 years is the mandatory minimum. And that is why lawyers do legal things. So that's why I say lawyer reacts, because the lawyer breaks it down. Somebody said, how much money do you think Jim Bob spent on lawyers? A lot of money. This is a lot of money. Can the court offer trauma counseling to the jurors? Sometimes they do, sometimes they don't. I don't think we will know if they do in this case. Sometimes they do, often they don't. I hope the jury does find that. Some of the jurors might be like, look, we did our job, we convicted someone, and that might be enough for them to be like, I am settled and I never want to think about this again, but maybe not. Will he go to federal or state prison? Very different experiences. He will go to federal prison. This is a federal crime. It is something in a jury room. We had one jurist say she understood the case better than anyone because she was from Compton, and some jurists thought that that was a valid reason. I mean, jury rooms can be wild. And if you guys have had jury experience, you understand, which is why there are times I'm just like, oh my goodness. How anyone gets convicted is always interesting to me, because you're just like, it is a lot. Jury rooms are a lot. Oh, sorry. I meant to answer that question. What do they mean in this case when they refer to piece of partial image? There were deleted files. So those were the images that were held the parts that were held after the file was deleted, like the ghosted image. So deleted, but not all the way deleted, but not all the way deleted. Did his sisters testify? Sorry, I have red hair on my face. No, his sisters did not testify. Bobby Holt testified. Question: when is it okay to go against spousal privilege when said spouse is being abused? Wendy, I hate to give such a lawyerly answer, but it really depends, because spousal privilege can be asserted by the other spouse. So it can depend on the circumstance, and it can depend on if it's as a witness, if it's as a victim. So it really, really does just depend. But it can happen, but it just depends. So circumstances are specific. Let's see. I'm going to try to get to as many as we can. Will Josh need to be kept in solitary confinement to keep him safe? It's possible. Thank you for your coverage of this awful topic, Jen M. You're welcome. It's possible. Just from my prosecutorial experience, the kid crimes are not generally well taken by the prison population, and celebrities can also be at risk. There can also be risk in prison of self-harm, but before sentencing, they will do all of the evaluations, and there will be evaluations from the prison to determine what level of safety and security is needed, and then they will do that. So, Deb Becker, why wouldn't it be mandated by law that his own children be examined by a doctor? I don't understand, because this is not a hands-on case. And even in hands-on cases, there aren't always laws, depending on the state, that require a government evaluation of the children. So why? State laws and there are limits to government power. So it really depends on the jurisdiction. They can ask, but it doesn't mean a parent has to consent. I answered that. I think it's a good question. Jim Bob's website has been down most of the day today. I'm not surprised by that. I love your channel. Thanks for the explanation. Janice, you're so welcome. Let's see. How much have you missed? I don't know, Deb. I think an hour and 16 minutes. I'm sure that question was directed to the chat and not me, because the law nerds are the best. And you guys are the best. A huge thank you again. Give our mods some love. A huge mod love thank you for riding in the middle of the day. It is super helpful to be able to have these conversations when stuff happens. Thank you to everybody who's subscribed. We banged. We're still like rolling towards 200K by the end of the year. I realize it's kind of a ridiculous goal of just being like, but 200 by 2022, but it just feels right. So if you are watching, I know there are over 8,000 of you here, and you are not subscribed, just consider helping a girl with her, her somewhat petty goals of reaching milestones that, are just numbers at the end of the day, but it matters. I love having a growing group of law nerds that value facts, not fuckery. We elevate the conversation up on this platform, even with our cursey words. Anna was told what he did and married him anyway. It seems that way. And it seems that way. Carrie said, I grew up in an IBLP and fundamentals church. It left me traumatized. Carrie, I can only imagine from what I've learned in this. And again, I'm not an investigative reporter. I'm a lawyer. I've been a lawyer for 14, 15, almost 16 years. I do deep dives into the legal stuff. I have tangential awareness from what I've read on like the Duggar Snark subreddit and other places, interviews with people who have left the church with sources that I trust, like Kate Casey on her podcast. And I can only imagine and empathize, and am hopeful that is able to be put behind you, because all of us hope that for you, because the law nerds are the best everywhere and anywhere. Let's see. Yes, Mr. Unicorn. Well, Brittany wasn't in court. Brittany's case was in court. We're going to talk about it Friday. So extra long ride tomorrow night. I mean, I don't even know what extra long means anymore. I'm always like, it'll be 2 hours, and 3 hours later, people are like, have you lost all concept of time? Yes. Time blindness. I also have a terrible sense of phonemic awareness, which has never been more prominent than in trying to cover the Jolene Maxwell case because I literally cannot. And people are like, here's the phonemic pronunciation. I'm like, that's amazing. Thank you for the help. However, I lack of phonemic awareness. And now I might just call her Jolene. We're just going to be like, Jolene. No, the great Dolly Parton does not deserve that shade. We cannot do that. Besides the IBLP and family pressure, Anna has 7 kids and no job skills. She relies on Jim Bob Jim Bob, whoever, for financial support. She'll never leave Josh. This is not specific to her circumstance, though. This is something that came up very often and very real in domestic cases in court, which is victims coming in saying, I understand what happened was bad. I understand that I went to the hospital. However, I have children. Because of my children, I cannot work. If this person goes to prison, what do I do next? And it is a very, very real problem and a very real consideration for in domestic relational cases, in cases where the children in the home are harmed. I'm not saying this is that case. I am not saying this is that case at all. I'm just saying that this is a very, very real problem that has to be overcome to prosecution when there are victims. This is a computer crime. This is images on the computer. That is what he is charged with. But when there are hands-on crimes, the other parent can be reluctant to report them for a variety of reasons. And the breadwinner going to prison is one of those reasons that does come up. And it is heartbreaking. Question, is there emotional support for jurors forced to see those images? Not always. And I hope they will seek that on their own. So not always. And not always through the court. This is just misopinionated, is just co-signing what I said earlier, that it is very difficult to understand our system. But it is look, our system is complex. Our system tries to make sure that the person whose liberty is being taken away is given a fair and just trial. They are able to see their accusers. They are able to see the information against them. They are able to know what they are charged with. They are able to participate in their defense. They are not locked away for 5 years pending some mystery charge from someone somewhere. It tries to be a good system. It continues to need improvement. There are factors that weigh heavily against people. Money and race and socioeconomic status all factor in. People's biases and prejudices all factor in. It is a human system, but it is generally a system that strives to be better, and there's room for it to be better. So I think that is what matters, but it is a complex system for sure. Allegedly, Angelo, personally speaking, I would need to take a month off to recuperate all the energy reading all this, or let alone being his defense attorney. What do you do for mental health aftercare? I do lots. Therapy, for one. It's one of the reasons on the Alec Baldwin video breakdown on his interview, I have partnered with Cerebral, which is a mental health care provider through your phone with licensed therapists, because I really do believe in it. But I have built in a system of support for me that includes rest, that includes knowing when topics are too much for me, that includes not talking about there's lots of cases going on, but picking what I talk about and what I don't, to make sure that I am protecting my own energy and only bringing up topics that I can help, and also not eat, sleeping, and breathing these topics. I had a friend visiting over last weekend and was basically offline most of the weekend and took a step away. But I do a lot to process that. I also therapy. I love therapy. Talk about therapy, but it's something that took time, because there are cases that I prosecuted that still stick with me. And I'm sure that's the same for defense attorneys and for other prosecutors as well. There are things that just stick with you, and then other cases that bring that back up for you. So I'm very careful to make sure that I am not trauma dumping on my audience, but also to make sure that I am bringing facts, and that I am not clickbaiting, sensationalizing, focused on monetization, that I am focused on bringing good, accurate content, but also that I'm not trying to dive into it all the time, not trying to stretch the content and do every single little update because it can be too much. So I set my own boundaries. I always share them with you all and make sure that when we're covering it, we're covering what matters and we're covering the court documents. And those are kind of all of the things that I do. I'm sure there are more. I love a good bath. I try not to shop or eat to deal with my feelings. Doesn't mean I haven't in the past, though. The jury will need counseling. Of course, the jury will need counseling, and I hope they are able to do it. I am so far behind in the chat. I'm trying. Will he have to register as offender? This statute, and I went through the statute. I'm going to research it a bit more. This statute does not have mandatory registration listed in the sentencing section, which is where it would normally be. So I'm going to dive a little bit deeper into that because I have not looked into it. And B, I had looked into the sentencing, but I did not look into whether this was one of those charges. So I'm going to do a little legal research on it, but not at this particular moment because I need some time to do it. But I will share that with you guys on Friday, and I will share that on social media. Christina says KJ keeps telling people that he's going away for 40 years for both. Well, that's just not accurate, and that's not going to happen, but that is not going to happen. So, consider the source. Bookmouse said everyone info on the worst of the videos. No, we're not doing no, Bookmouse. No, we don't need to cover that. Nope. I noped right out of that. No, but nope. We're gonna nope right out of it. 9K viewers. This is the most I've ever seen. Natalie's World. There are days we definitely get into the 9, 10, 11s, but yes, it's a lot. Hello, everyone. Thank you. It's a lot for the mods. And we do have rules up in our chat, so I appreciate that. Motion to investigate the most interesting and funny cat lawsuits one Friday. I mean, Fred, should we do cat lawsuits? Fred, cat lawsuits? Baby. There was a lawsuit about a DUI on a horse that we covered in law school where the opinion was written in iambic pentameter, which was hilarious. There's been a few lawsuits that are good, and there's also a few food lawsuits I wanted to cover. Oh, and LuLaRoe and Peloton suing each other over bras. Or somebody suing somebody over bras. There are other lawsuits that are a little lighter that we need to do. Mr. Unicorn, thank you for the comment in the chat. For sentencing, can either side subpoena people to testify? Yes. Can anyone testify like one of the sisters if they wanted to? Yes, they absolutely can. So they absolutely can. Question, Rachel said, why aren't CP crimes considered violent? There's two parts of this, and I'm really glad that you asked. The creation are separate code sections and separate charges, and this is super dark shit to talk about, but the creation are separate charges. So if someone was creating it, that is separate. And that can go into the realm of abuse, and that becomes a different category of crimes with higher sentences. With images on the computer, this is a crime that covers whether it is digitally created, not digitally created. So the receiving and possessing is not considered a violent crime. It is a digital crime because there is not something that they, specifically them, is doing to harm. The person who created the harm. And there's not really like a analysis of the market for this, but for people downloading it, then people wouldn't make it. It has to be the person doing the thing. So this is considered nonviolent because it is digital images. So there's that. And I understand, but for a federal court, there is a difference between a homicide and an image on a computer. And so while I think images on the computer are horrific, I understand why the law treats those two things differently and treats the creation and the people who create those images different than the people who create the I don't know. I don't want to say the market because it's just sounds so wrong, but create the I guess it really is the demand for such images. So that's what it is. Let's see. Somebody said maybe they will do consecutive. They will not do consecutive sentencing. These charges cannot be sentenced consecutively because rules and laws, they are lesser included of the other. So there will be a primary charge and a lesser included charge. The lesser included charge gets subsumed. These cannot be sentenced consecutively. If they are both sentenced, they will be sentenced concurrently, which is why the max is 20 years. Um, Question. So, because his parents mishandled and lied about what he did to his sister on paper, there's no previous conviction, even though he admitted it. I'm not going to assign blame, but I'm not going to dispute what you've said. But there is no previous conviction. However, I will say that had it been done differently, had it gone through the juvenile system, that conviction would not necessarily be considered because he was a juvenile at the time, and a juvenile conviction would not be used to add to his sentence here. So because he was a juvenile, that factor also very much matters in this. So it's not just the fact that he wasn't convicted in court because of all the things his family did. He was also a juvenile. So had it gone through a juvenile court process, it is entirely possible that he would have a juvenile conviction, but a juvenile conviction wouldn't count to add to his sentencing. Hopefully that makes sense. Um, could he genuinely appeal? I mean, he can and he will. He will appeal the court's rulings on the prior evidence. He will appeal the court's ruling on the digital evidence, the search warrants, stuff like that. He will appeal the court's rulings. Yes, he can genuinely appeal. Do I think it stands a chance of winning? Not based on what I've seen. Hopefully you talk about Travis Scott and Smollett tomorrow. I definitely intend to. Let's see what happens in the world between now and then. Um, I wish it was 5 years minimum per image, but I get it. I mean, there are times when they will charge per image, but these were image sets and some of them were ghosted images that were deleted. In this case, I think that would have been difficult. In other cases, sometimes that does happen. It did not happen in this case. So Lisa White said, thank you for clearing up a lot. You're welcome. It's what I'm here to do. At least, the experience that I have as a former prosecutor can help at least bring the facts, even when we think the facts suck. And it's okay to be like, these facts suck. I think he should go to prison for whatever amount of time you think. I would like you to be able to know that you are allowed to have that feeling and be like, this sucks. Put this person in prison forever. Fuck them. I get it. But also, I don't want people to go into the sentencing and being like, he should get 20 years without knowing what the realistic probabilities are here. The mandatory minimum is 5. I can reasonably see 10, double the mandatory minimum for someone with no prior convictions. I can reasonably see that. I can also see 8 to 12. Depending on what the sentencing memos ask the court to consider, could it go up to 15? It could. Do I think it will? I don't know. How does federal prison work with visitation of family? Family are generally allowed to visit. There are rules. The rules are probably different right now because of COVID, but there are rules about when and how they can visit, but they are generally allowed to visit and they are visiting rooms. They're not behind glass like you see in Legally Blonde when she's visiting in jail and she's like, I brought Cosmo, and they're talking through a phone. In federal prison, they are generally family visiting rooms where you get to sit and be with your family. They are observed and monitored. Sometimes there's a guard in there. Sometimes it's just a camera. It depends, but they are allowed to visit. Depends on how far away someone is to how often their family can do that, which is something that comes up in California a lot. When people are sentenced in California and then they're housed in Georgia, they're like, but my family can't come to see me. And that does come up. I already answered this question about solitary, which shows me how far behind I am in the chat. It's possible. Question, what is spousal privilege? That's a great question. I should have illuminated. Spousal privilege is the fact that when you are married, someone cannot be compelled to testify against you. So the government can't subpoena Josh Duggar's wife and try to make her testify. And if she wanted to testify, Josh Duggar can say, no, our communications are privileged. She can't testify. The way he tried to block Bobby from testifying, well, he through his lawyers. So there are exceptions to that depending on the facts, but that is the general. Ivan's, I hope I said that right. Yes, this case was dark, but you do such great social work. Thank you, bringing content and awareness. Thank you for that, Emily. We love you. XO from the UK crew, and thanks to the mods. Thank you so much. It is heavy, and I think it should be treated with appropriate solemnity, but also, he's guilty, and Josh Duggar is going to go to prison. And what was Observe Logan from Observe? I totally fangirled. He responded to me on Twitter, and I was like, ah, I love Logan's content so much. He did a great breakdown, a body language breakdown. I think Logan is so incredibly mindful and thoughtful in his content. And I just totally had a moment, but I need to go find what he responded on Twitter because it was such a appropriate and thoughtful comment, and I of course expect nothing less. If you guys want to follow me on Twitter, you can. It's at the Emily D. Baker. But I said I got to watch Observe's video on Josh Duggar. I'm sure Logan isn't surprised by this verdict either. And he said, I can't. Can I make this bigger? I can't say that I'm faint with shock. Warmest regards to his new housing situation. Yep, warmest regards to his new housing situation, and that's exactly what it is. It is well stated of a have fun in prison. That's probably not going to be ideal for you. So let's see. Did I answer the question of whether CPS can get involved? It will be, look, it is not a hands-on crime. So it is really going to depend on what happened with this investigation, what law enforcement turned over. It is possible. I don't know if it is likely, particularly since he is going to prison. So he will be out of the household for quite a while. Matt Bond, when you delete files, the file stays, but it's removed from the table of contents. When new files are added, it damages and fragments the old files. Matt Bond, you explained that better than me. I am not a tech expert. I know some things. Can spousal privilege be claimed after divorce? Again, there are ins and outs of this. It depends. For things that occurred during marriage, yes, it can in most jurisdictions. I cannot speak for all jurisdictions because I truly do not know. Thank you for your exposition on this difficult case. In your estimation, what is the likelihood of an appeal? 100% he's going to appeal. He will 100% appeal. Do I think that will win? No. Will I cover it? I will tell you what the appeal is based on when it's filed. But no, I don't think it will win. But yes, I think he will appeal. So, yeah, I think prison is going to be an interesting and different experience for Duggar. It seems like he's used to kind of being in charge of things. Sky Bloom, some question in a later video. Could we talk about why juveniles can be charged as adults? I'm always so confused when this happens. I thought to be an adult, you have to be over the age of 18. We can cover it. The laws vary state by state. The prosecutorial discretion on that varies state by state. But there is a cutoff for that in each jurisdiction. So if you're under the cutoff, some places it's 16. I don't remember if there's still states where it's 14. I would really have to do legal research on that. I don't want to put out misinformation. But if you're below the cutoff, you cannot be charged as an adult. And there are also certain categories of crimes where it is appropriate for the prosecutor, or legal, I guess I should say, for appropriate gives a value judgment, but it's legal for the prosecutor to seek the greater penalties. And again, when you prosecute someone as an adult, those convictions stay on their record and can be used to enhance other convictions. They can be sentenced for longer than they could if they're a juvenile. They're housed, oftentimes when a juvenile is tried as an adult, they are still housed in juvenile custody until they're convicted. And then it depends on the jurisdiction. So it depends. The Upside said, what type did you practice? I currently only do consulting. I was a criminal prosecutor for over 10 years in the county of Los Angeles. So I was a deputy district attorney. I've also worked for judges. We could go through the resume of Emily. I've worked for civil judges. I have worked with the AUSA's office in the tax crimes division. What else have I done? I've done other jobs, non-law, but I've also worked in corporate formations and business law in the online space after I left the DA's office. And now I am everyone's favorite legal commentator. The podcast, by the way, The Emily Show, hit number 3 in entertainment news in the US. And has been like charting around the world. You guys have been loving the Emily show, so thank you. It's been great. 5 minutes till Fundy Fridays, Emily. Okay, well, we'll have to hop, so we don't want to step on anybody's toes. Will CPS take the kids? Very, 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 very unlikely based on this. If something else happens, I reserve the right to reassess. But you guys are like, Ghislaine, Emily. I know it's just never going to happen. It's like trying to make fetch happen. How does this conviction affect the NDAs on the family and adult children? Does it void them due to a criminal conviction? Julie Andrews, I have not seen the NDAs. I imagine they are probably not floating out there. But if what you are asking is if there is an NDA, does it prevent someone from speaking at a sentencing? No, it does not. NDAs do not shield from participating in process, in criminal process or in civil process. For example, an NDA can't stop you from suing someone. It can stop you from saying things. An NDA can't block you from cooperating with the police. An NDA doesn't block those things. So if there is an NDA because of the show where you can't talk about certain things, it doesn't stop you from testifying at a sentencing. And whether somebody would choose to break an NDA in this circumstance with advice of counsel and just do something, then they may. Oh, excuse me, my nose. Question, because of his parents. Wow. I think we already covered a similar question to that. I'm going to try to catch up on the chat. Anna, it feels like Anna drew her line. I married into a family that was IBLP and had the same issues as Josh with an older sibling, hands-on with young siblings, statute of limitations. It sucks. Sweet and sound, it does suck. However, hopefully sharing your story when and if you want to will help others understand that it's not okay, that there are remedies and resources, and that they are safe to seek those, and that, they don't have to. But I also understand for people that leaving your entire family, leaving your religion, and leaving everyone who supports you is terrifying, and it feels very unsupported. Andrew Knapp, just on the trail of what I was just saying, also left IBLP years ago. I was walking out when the leader had a scandal break. Fascinating to see it all fall down. GH in French, as in soft J, Galeen. Jolene. If it is your first, as we wrap up the rest of the questions, it's been almost 2 hours. As we wrap up the rest of the questions, if you are new here on this live, go ahead and pop a 1 in the chat. And thank you for being here. Thank you for subscribing. Thank you for making it bing bong. I think we might, let me take a look. We might actually be close to making it bing. Oh, I forgot to end the poll. Sorry. Sorry, y'all. And I need to put the child abuse hotline in the description. That will be done after the video. Yeah, we're almost at another bing. We're almost at 183. So thank you all for supporting the channel with your subscription. It really does help YouTube know that we are doing educational content, not salacious content. And it's okay to let people see what we're talking about, because we're talking about the facts, even though sometimes the facts are fucking ugly. Is it true that he will only get time for one of the counts? Yes. So 20 years plus the 5? No. 5 minimum, up to 20. And that's the judge's choice. Yes. Minimum 5. It can go up to 20, no more than 20. Minimum 5, up to 20. So he can get any 5, 6, 7, all the way up to 20. 20 is the max. He's not going to get 20. I will be shocked if he gets 15, truthfully. And that's just based on my experience. I would be happy to see him get 20 years. It's just not going to happen realistically. I think 8 to 12 is realistic. Can he get the minimum sentence? He can get the minimum sentence. I would be surprised if he does. I would be surprised if he gets the minimum. I think it will be somewhere in that 8 to 10 range. Could it be more? Yes. Could it be less? I would be so fucking pissed if it's less. Like, if he gets the mandatory minimum, I will just be angry. I will be angry. Very, very angry. And I will be shocked if he gets 15. I will be pleased, but I will be shocked. So, I don't understand how you get convicted of 40 years and serve 5. It makes no sense. Laffy Taffy, he's only facing a minimum, He's only facing a maximum of 20. He's not facing a maximum of 40 because the counts aren't cumulative. Like if there's and I understand sentencing is really confusing. And so for those of you who are like, no, I get it, Emily, I get it. For those of you, sentencing can be confusing. But if somebody commits like a string of robberies and it's like you rob, I don't know, 7-Elevens and you rob 4 different 7-Elevens. Those are 4 different crimes. So you can be sentenced on each one and you can add it. So if you get sentenced for 5 years, you can do 5, then 10, then 15, then 20, and it's consecutive. You do the time on this one, then this one, then this one, then this one. Unless the judge really likes you, and then they can run that concurrently and you do 5 years on 4 different counts and you do all 5 years at the same time. But when the charges are part of the same crime, possession and receipt, when they are lesser includeds of each other, you cannot be sentenced on both and have it be consecutive. He can be sentenced on both, and then they would run at the same time in case there's an appeal and something gets tossed out. You don't have to resentence it. But you can't do, 20 years on count 1 and then 20 years on count 2 back to back consecutively because they are included. The 2 crimes are included in each other. It'd be like if you got convicted of a assault with a deadly weapon with a gun, you can't also be convicted of that same assault without a deadly weapon. That assault is a lesser included of the greater crime with the weapon. I'm hoping that makes sense. I understand sentencing is confusing. We haven't even talked about like good time, work time, and percentages of sentencing and stuff like that. In federal, I will say this for federal. In federal, you tend to serve more of your sentence day for day than you do in state courts. Day for days in state court, sometimes it's 3 to 1. So if you do 1 day, you get like credit for 4 days. So it's like each day you serve, you get 4 days. So you go through your sentence faster. In federal cases, that is a lower percentage. So you do a longer amount of time that you are sentenced. And that is something that is taken into consideration by the courts when they sentence. Poppy Crew, thank you. Thank you for explaining all of this. As a survivor of this type of abuse, I really appreciate how you handle every bit of this. I look, I'm not here to re-traumatize the audience. I know so many of you have dealt with trauma either as kids or as adults at the hands of others. And that is something to be mindful of, but also it should be talked about in the light that the justice system isn't perfect for victims of crime, but it can get it right. And there are options, which is, again, why I'm going to link the Child Abuse Hotline down below. Question, why does it take so long for sentencing to happen for a case that seems relatively straightforward? Mary Catherine, that's a fantastic question. It is so the attorneys can do their sentencing memorandums and so they can bring in individuals for a full in-depth sentencing hearing. And so the prison system can do all their evaluations because they do a whole bunch of workups. So that is why it takes time, but he's going to be in custody until that happens. And that's something I should have thought about earlier when I was saying they might take him into custody now, not later. But because there's a mandatory minimum sentence, it only makes sense that they would take him into custody. And for him, it's like you're starting your 5 years, start today. Like your mandatory minimum, you have to do 5 years, it starts today. And that's appropriate. In other cases where there's no mandatory minimum, they don't always take people into custody that haven't been in custody. I think it was wise that they did. I'm glad that they did. So that's why it takes so long. And that's in federal, that is appropriate. 4 months isn't a lot. I've had sentencing on my own cases in state court that tends to move a bit faster, sit out 6 months sometimes, and it's always frustrating. KM, cool. How likely is the 5 additional to be added to his sentence due to the age of the individual in the images? Not, they didn't, the sections that he is charged on just has that 5-year minimum. So though they alleged the, under the age of 12, I don't know if they're going to use that as a sentencing enhancement. Of course, we can see what the government says in their sentencing, but his mandatory minimum is 5 years. They thought him marrying Anna would be the fire break in abuse, but sadly made things worse. I hope they don't spin the quote, the devil won in court BS. I mean, the jury absolutely said what it is. Um, I think I answered about concurrent time, so I'm going to try to catch up on the chat, and then we are going to let the mods go. I am going to go eat because then we have our later. So Anna says if he does have to register as an offender, does that affect his ability to see his kids or be alone with them? It generally doesn't, and I've never seen it apply to one's own children if one's own children are not the victims. So it depends on the circumstances, but generally not. Um, Anna asked, why is the lesser charge stayed? When the lesser charges are sentenced and the sentence is stayed, they can either be, well, it depends. In this case, they can either be served concurrently at the same time or they can be stayed. We'll just see what the judge does. But when it's served, when it's stayed, it's because they're not serving a sentence on it. It is a sentence that is in a holding pattern, essentially. So, oh, I'm so far behind in the chat. I apologize. Thank you, Emily D. Baker, for the facts. Much love from Memphis. Give Fred and George scratches from me. I will definitely boop the floofs later. I don't know where the other one is. I think he's probably up with my oldest. Laffy Taffy said, Emily, those amazing pants with all the pockets that sponsored you yesterday are out of almost every size. Did you know if they will restock and sponsor you again? We have a contract, so we are definitely working together. I am not surprised that they are out of stock during the holidays, but I will reach out and ask that question and let you guys know on social. Let's see. We're going to get to another. Jeff Ray said, I am so glad I found you from your Brittany coverage. This topic is heartbreaking and you have done so well. Thank you. You bring me knowledge and laughter, which is hard with what you cover. Thank you, Emily. You are so welcome. I try. I absolutely try. So Jess Rotter, Emily, thank you so much for the facts, not the BS. We are definitely here for the facts, and it's just hard. It's just ugh. Advice for jury duty: be honest, and be forthcoming, and don't be afraid of it. It can be a very, very interesting process. Why is there an estimate 4-month time frame for sentencing? Why so long? Purple glitter tears. I hope that my previous explanation covered that. Sentencing memos, paperwork stuff. Dakota said, question, Bobby Holt is stated that there was supposed to be a trial in 2007 for the acts against his sisters. If that happened, he would have been a legal adult. If it did, would that be a conviction? Not if the crime occurred when he was a minor. So if he perpetrated the crime when he was a minor, even if he's tried as an adult, because there's that 10-year statute of limitations, it would still be a juvenile conviction because he was a juvenile when it occurred. Hopefully that makes sense. Even if he's convicted and he's age-wise an adult, still would have been a juvenile. Sam said, thank you for covering this in an accurate and respectful way that doesn't feel exploitative. I always try to. It's something that was hard to watch in my own cases when stuff got sensationalized. And I didn't like doing media cases at all. So it's definitely something that I take to heart just based on my own experience and based on, I don't know, spending 10 years across the table from victims of crime, talking about all the shit that they've been through. The Reavers must be so happy to have their home back and no longer hosting the pest. I am sure that it is a relief for them as well. So I'm going to try to sweep a few more questions. I am so far behind in the chat. To everyone who's joined as members, thank you. I will see you tonight in the members only live stream. There are lots of questions and I'm trying to get yelling my name, Jolene. Jolene, 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 Jolene. I can't even pretend. Have you guys heard Miley Cyrus's cover of Jolene? It's a number of years old. It's fucking amazing. It's a good palate cleanser. It's such a beautiful song. Dolly Parton is such a damn good songwriter. I don't care if you like country music or not. Dolly Parton is a great storyteller. Let's see. Ezreal Abadnon. I tried to get that right. I hope I did. I am so glad justice was served here. Same. I hope his sentences are consecutive. I'm sorry they won't be. Will he be allowed to see his kids in prison? I hope not. Prison, not jail. Yes, prison. Yes, he will be, unless the judge orders otherwise. But here's why I say that. Because Oh, somebody commented on my nails. Look, they're green and red and glitter. We did all the things. Because they didn't disallow him from seeing his kids pending this, I don't think they will bar his kids from visiting him in prison. I don't. The judge could order it, but I don't know if they will. And they didn't pre-trial, so I'd be very surprised if they did. I hear the Smollett jury is coming in. Well, that would be important. Let me check the Twitters. Fascinated. We'll just stop this live and start. I'm teasing. We'll talk about it tonight. Let me see if I see anything on the Smollett jury, because if I do, I do want to go and take a look. I will be fascinated. But it's not televised either, which is so annoying. Even though it's state court, they're not, they haven't televised that. So let's see what the Twitter says. Jury reaches a verdict. This is from, let's see, moments ago. Let's see what the jury says. All right, verdict is in. A verdict was reached Thursday, nearly 3 years. Jurors deliberate. They heard 6 days of testimony. I guess they haven't read it yet because this doesn't say what it is. So I wonder what time they will be doing it, which is good because I'm going to be wrapping up here. So I will share that on the social medias. We'll talk about it tomorrow. Thank you all for being here. You guys are like, is he actually getting prison time? Yes, he is getting prison time, a minimum of 5 years, and we'll go from there. Cherie, I covered this earlier on in the stream. The charges can't run concurrent. They can't run consecutive. They have to run concurrent. They are lesser included. So I'm going to go take a look and see what's going on with the Smollett verdict. We have been streaming for 2 hours. I see that it says they reached it. I don't see reporting on what it is. So, and I don't see this being updated. So I will go do that. I will share on the Twitters and the Instagrams. And we will see when they come in. I mean, it's the end of the day, so I won't be surprised. So somebody's saying guilty, but I don't see. Let's see. Let me Google one more time. Let's see. Jury completes deliberations. Verdict is in. We're waiting the decision. Jury has reached a verdict. I'm not seeing anyone say what the jury verdict is. So I will cover it on social. I appreciate all of you. Thank you for being law nerds. Thank you for being respectful in the chat. I will see the members here live at 7 o'clock Central tonight in just a few hours. I will see everyone tomorrow night for Friday Night Live. If you do not follow me on the Instagrams and the Twitters, I am at the Emily D. Baker. If you're not subscribed and appreciate the content, just subscribe. It helps support the channel, helps YouTube know that we're putting out the facts and not the fuckery. And I appreciate that very much. Thank you all for being here. A huge thank you to the mods for the extra ride. It always is a lot of work when we are busy because we do take a considered conversation approach to our lives. And that means the most to me. Thank you for being respectful of our space here as law nerds. Take care of yourselves. Take care of each other. I will see you in the next one.
Hey there. If we haven't met yet, I'm Emily D. Baker.
That totally wasn't my outro. We're not starting over. This is the outro. Thank you. Sometimes I hit the wrong buttons. If you want to know, does Emily produce her own show?
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.